1800, almost leading to a severe constitutional crisis. The framers can't possibly have known that. They're devising rules in the abstract, so they can't possibly contemplate all the things that experience will toss up that we can benefit from. Third and finally, when you're making decisions without knowing the consequences, yes, there's a certain appeal, but there's also a certain drawback because we clearly believe that sometimes it's important to make decisions fully aware of the way they play out and affect people in the real world. If we didn't think that, it's hard to understand Article 3's case and controversy requirement, which requires federal judge not to resolve important issues of constitutional law in the abstract, but rather in the context of specific cases and controversies. That's because sometimes we think a concrete decision-making context is vital to deriving good rules. All right, moving on. The final, and I think perhaps the principal supposed virtue of originalism is that it constrains judges because it prevents them from simply writing their own personal preferences into the Constitution. Federal judges, of course, are not elected. They are at most remotely politically accountable. It sounds awfully anti-democratic for these federal judges simply to be inserting their own values into the Constitution. Now again, I don't deny that this is a virtue of originalism. I don't think originalism eliminates judicial discretion, but I do believe there is less judicial discretion when you are administering an originalist methodology than you're doing whatever is the opposite of originalism. I suppose Justice Breyer's living constitution, the active liberty notion. All right, so I don't deny that. I think there is a virtue in constraining judges. I do think there's a risk that if judicial review ends up being nothing other than judges writing their values into the Constitution, maybe that's something that ought to give us pause. But notice there is a huge offsetting vice right off the bat, and Alan mentioned this, although I think only in a disparaging aside. Originalism doesn't just tell judges to leave alone statutes that don't violate the original understanding. It also tells judges to strike down statutes that do violate the original understanding. Now think about what that means. It means judges are striking down laws passed by contemporary legislators because of value choices made 200 years ago, people who have long since passed from the scene. There is an enormous dead-hand problem with originalism. Why is it more democratic to be ruled by people who lived 200 years ago than by judges who, although unelected, at least have the virtue that they live in the same historical moment and come out of the same culture as the rest of us? All right, so think of a few salient differences between the framers and us, and I think the problem will be immediately apparent. At least three different kinds of differences that I can think of: ideological, circumstantial, and differences in the factual assumptions they made about the world. With regard to ideological differences, of course, some of them are quite stunning. The founding generation thought it was okay to hold property in human beings. The founding generation thought that women, once they married, had their legal identity merge into that of their husband. They should no longer be able to contract. They should no longer be able to own property. The founding generation believed that people who did not own significant amounts of property should not be allowed to participate in political decision-making. Those people should be disenfranchised. I doubt many of us believe any of those things today. Why in the world should we expect people who believed all those things to have written a constitution that would make sense in deciding how we should govern ourselves today? Okay, with regard to changes in circumstances, which plainly affected the sort of constitution that they were committed to 200 years ago, consider the fact that in 1787, transportation and communication were primitive by today's standards. Consider the fact that the American economy in 1787 really was one of mostly subsistence agriculture. There were no national markets to speak of. There was relatively little interstate trade. Surely both of those circumstances would have had a dramatic impact on how the framers thought about what the power of the national government should be, what's the scope of its regulatory authority. Similarly, the United States played no significant international role in 1787. Surely that affected the founders' notion of how powerful the president should be. We live in a world where the United States is the only superpower left standing. Why should a constitution written with their set of circumstances in mind presumptively be the right way to order our political affairs today? Finally, with regard to erroneous factual assumptions, I'll just note one, but I think it's a very salient and important one. The framers abhorred political parties, and they assumed that political parties would not exist under the Constitution. That assumption was proven wrong very, very quickly, yet that assumption almost surely influenced their views about the separation of powers, the degree to which there would be inter-branch coordination of purpose, and the risks inherent in the possibility of the various branches coordinating among themselves. Right? In a world without political parties, the President and Congress might have institutional incentives to oppose each other. In a world with political parties, the President and Congress often come from the same political party and thus don't necessarily do a very good job of monitoring each other. Okay, now you might be thinking in response, I'm sure Alan is ready to jump up and say in response, we can always amend the Constitution. If we think they made bad choices, if we think they had erroneous assumptions, we can amend the Constitution. Judges don't have to amend it for us. Better that we, the people, do it ourselves. Article 5 doesn't solve the dead hand problem because it is so hard to amend the Constitution. You need 2/3 of both houses of Congress. You need 3/4 of the state legislatures. There are lots of amendments in American constitutional history that had majority, supermajority support and never got into the Constitution. So I don't think you can say we, the people, consent to the status quo simply because we don't amend the Constitution. The Constitution is very difficult to amend. Now, there is another brand of interpretation. I want to mention this very quickly, but I think I won't delve into it because I don't want to go beyond my 25 minutes. We want to hear your questions, especially if they're directed to Alan. This is the idea of translation or soft originalism. So many people have tried to split the difference between originalism and the living Constitution by adopting an intermediate point on the spectrum and calling it soft originalism, or it's sometimes called translation. And the idea here is, rather than looking at the founders' specific commitments on specific issues, we look at their general principles and then we apply those to accommodate changed circumstances. So rather than asking meaningless questions like, would the framers have thought that Congress, under its power to regulate interstate commerce, could regulate airplanes when Congress couldn't understand what airplanes were in 1787, we say, let's take the founding commitment to federalism and limited national power and see how that translates in a different world with different technology, different globalization, the development of international national markets, and so forth. Okay? This is an effort to avoid the dead hand problem of originalism, but also the extreme subjectivity problem of the living Constitution. The problem with soft originalism is that it can't work. It is, first of all, entirely indeterminate. Fact of the matter is, we don't know what James Madison would think of the Gun-Free School Zones Act, to take an example from a recent Supreme Court Commerce Clause case. You can't possibly know what the founding generation would have thought about issues which they really can't possibly have thought of. Even aside from the indeterminacy problem, there's a larger problem, which is, I think, translation is basically incoherent. Essentially, the translationists are saying, let's take one aspect of the founders' commitment, stated at a high level of generality, but treat the rest of the world as a variable. So let's say the framers were committed to federalism, limited national power, we know that, but we'll treat other things like changing technology, globalization, we'll treat those as variables, and we'll say, how do you take their commitment to limited national power and apply it in light of those changed circumstances? The problem with translation is it's always arbitrary what aspect of the past you treat as a variable and what as a constant. The framers were committed to federalism and limited national power under the set of circumstances in which they lived. If they lived in a different set of circumstances, maybe they wouldn't have continued with their commitment to federalism. Lots of people today are not all that worried about the national government expanding in scope, right? The framers, if they lived today, also might not share that concern. Maybe they would, we don't really know, but I think it's incoherent to say, let's simply take their commitment to limited federal power, since all we know is they were committed to it in a set of circumstances that has radically changed. Okay, so I just have 2 points left. My next to last point, the best, and I alluded to this already, the best evidence that originalism is not particularly attractive comes from looking at the way self-professed originalists actually apply it. And here I'm thinking of Alan's former boss, Justice Scalia. Okay, I want to suggest to you that they are not very consistent in their application of their own preferred methodology. If originalism is really guiding their decisions, then they should reach outcomes that are politically unpalatable to them when an originalist methodology dictates those outcomes. Obviously, if they only apply originalism when it yields the outcomes they like, then it's not originalism that's doing any work, it's their own political preferences. Right? It's just a convenient rhetorical device that you invoke when it conveniently justifies the outcomes you like, but then you disregard it when it doesn't. And I want to suggest to you that's exactly the way originalism is